What matters most, and this is a matter of public record, is the conclusion of the Secretary-General. Despite a full year of intensive efforts, there was no discernible progress towards a resolution of the controversy arising from Venezuela's contention of nullity. And so, on January the 30th, 2018, consistent with what he had communicated to the parties on December the 15th, 2016, the Secretary-General issued a public statement and sent letters to each of the parties. He announced that he had chosen the court as the next means of settlement. Despite the intensive efforts, the Secretary-General had concluded, and the words are to be found at tab 20 of your folder, significant progress has not been made towards arriving at a full agreement for the solution of the controversy. Accordingly, the Secretary-General has fulfilled the responsibility that has fallen within the framework set by his predecessor in December 2016 and has chosen the International Court of Justice as the means to be used for the solution of the controversy. End of quote. Mr. President, members of the court, the record is clear. More than 50 years have passed since the signing of the Geneva Agreement. 4 years were fruitlessly spent before a mixed commission from 1966 to 1970. 12 years were then spent on an equally unavailing suspension of the Geneva Agreement from 1970 to 1982. 37 years ago this week, Guyana and Venezuela jointly entrusted the Secretary-General with exclusive, unfettered, and irrevocable responsibility for selecting the means of settlement of the controversy. After 6 years of further discussion between the parties and the Secretary-General's representative, the good offices process was established in 1990 with an enhanced mandate of mediation for the year 2017. That means of settlement ran its course for more than a quarter of a century. It has produced no progress whatsoever. Nothing. Rien. The existence, basis, validity, and nature of the Secretary-General's right to select that process has never been called into doubt. To the contrary, Venezuela and Guyana have repeatedly and consistently reaffirmed the Secretary-General's exclusive responsibility and right under the Geneva Agreement to select the means of settlement. Venezuela has never previously disputed the Secretary-General's discretion to select the means of settlement from those listed in Article 33 of the United Nations Charter. The good offices bore no fruit. In 2018, the Secretary-General concluded that significant progress had not been made towards resolving the controversy. We say that conclusion was reasonable and it was justified. In those circumstances, the Secretary-General was plainly entitled, and indeed, we say positively required by the words of Article 4, Paragraph 2 of the Geneva Agreement to, I quote, choose another of the means stipulated in Article 33 of the Charter of the United Nations. End of quote. Another in the singular. The Secretary-General's choice of judicial resolution by the court was reasonable. It was based on legal advice, and it was and is lawful. The Secretary-General simply could not be expected to go on forever and ever with a hopeless and useless exercise. He did not take an impermissible shortcut, as Venezuela puts it in its recent memorandum. Rather, after decades of futile negotiations and mediation, the Secretary-General concluded, in the exercise of the responsibility, rights, and discretion granted to him by the Geneva Agreement that the next means of settlement shall be judicial resolution by an independent tribunal applying the rules of international law. The Secretary-General proceeded with the utmost care and deliberation. He had a number of options available to him. He chose this court, the principal judicial organ of the United Nations. That was a first. It was a reasonable choice. It was a sensible choice. And it fell fully within the discretion conferred upon him by the parties under Article 4, Paragraph 2 of the Geneva Agreement.
The parties presented a massive volume of documents on effectivité, covering 300 years of Spanish, Dutch, and British rule in the disputed territories. On 3 October 1899, after extensive deliberations, the tribunal established the boundary in unanimous award. The result was widely hailed as a victory for Venezuela. The Venezuelan minister in London described it to his Minister of Foreign Affairs in these words: "Greatly indeed did justice shine forth when in the determination of the frontier we were given the exclusive dominion over the Orinoco, which was the principal aim which we sought to achieve through arbitration." The following year, in 1900, Britain and Venezuela established a joint commission to undertake the physical demarcation of the boundary. By 1905, after years of arduous work, the boundary was demarcated with pillars and geographic features stretching 825 kilometers from the Caribbean coast to the tri-junction point with Brazil in the Amazon basin. The Commission produced an official boundary map with the clear specification of the boundary line with the Arbitral Award of Paris, according with the Arbitral Award of Paris. This map appears at tab 2 of the judge's folder. The 1905 map was exceptionally accurate. It followed 15,440 points from the monument at Punta Playa in the north to the top of Mount Roraima in the south. Those points are confirmed by modern satellite imagery.
That day in Paris, at the end of the 19th century, is now a long time away. 120 years have passed since international law spoke. During that time, colonization in British Guyana came to an end, and Guyana has now enjoyed more than 50 years of independence. That might suggest a rather ordered past, given that the boundary was definitively settled a long time ago. But that would be wrong. In a word, we are here because, contrary to international law and to the binding award of 1899, the Bolivarian Republic of Venezuela, our neighbor to the west, has cultivated a nationalist passion to disavow that day in Paris and lay claim to almost 3/4 of Guyana. It was not always so. The arbitral proceeding in Paris was, after all, instigated at the behest of Venezuela. And Venezuela enjoyed and continues to enjoy the gains brought to them by the arbitral award. Yet, the process that brings us here is rooted in Venezuela's repudiation of that award. Repudiation more than 6 decades after it was handed down, at a time that seemed propitious to it, the very eve of Guyana's independence in the 1960s.